I'm ready.
Jefferson County Court of Law number 2 is back in session. Next case is cause number 330-566. Case is style of State of Texas versus Gary Christopher Barber. Mr. Barber, would you please raise your right hand? Mr. Barber, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth shall help you God? Mr. Barber, you may put your hand down. How are you doing, Mr. Barber?
Fine, how are you?
I'm doing fine. Thanks for asking. Mr. Barber, you're here with your attorney, Attorney Langston Adams. Attorney Adams, how are you doing?
Doing well, Judge.
State is represented by Attorney Raymond Shearer. Attorney Shearer, how are you doing?
Doing good, Judge.
I'm gonna read this affidavit of allegiance. Mr. Barber, I have before me a document that is titled information. This information alleges that on or about July 23rd of 2020, while you were in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed the Class B misdemeanor offense of driving while intoxicated. Mr. Barber, do you understand what you've been charged with? And to discharge, Mr. Barber, how do you plead? Guilty, not guilty, or no contest? Now, you pleaded no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges? Mr. Barber, I also have before me a document that is titled misdemeanor plea admonishment, also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, Your Honor.
On page 2 of this same document, there's a set of initials, GB, on a line next to a box that's checked nola contingere. Are these your initials?
Yes, Your Honor.
On the next page of the same document, there's a signature above the line that is titled defendant. Is that your signature?
Yes, sir, Your Honor.
On the next document, this next document is titled trial court certification of defendant's right of appeal. Do you recognize this document?
Yes, sir.
And is this your signature on the line that is titled defendant?
Yes, sir.
There's one box that's checked at the top of this document. This box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir, Your Honor.
I also have another document here. This document is titled discovery certification. Do you recognize this document?
Yes, sir, Your Honor.
And is this your signature on the line that's titled defendant?
Yes, sir, Your Honor.
Mr. Barber, before you sign and initial all of these documents that I've just mentioned, did your attorney go over these documents with you? And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir, Your Honor.
Mr. Barber, are you a citizen of the United States?
Yes, sir, Your Honor.
State, I have before me State's Exhibit Number 1, the misdemeanor plea admonishment, and State's 2, the probable cause affidavit that is in the court's file. State, you like to offer States 1 and 2?
State would like to, Your Honor.
Any objections?
No objections.
No objection. State's Exhibits 1 and 2 are admitted. Mr. Adams, you've advised and counseled Mr. Barber. Is there any evidence that he is currently mentally incompetent to stand trial?
None.
Mr. Barber, your attorney, Mr. Adams, has advised and counseled you. Are you satisfied with his representation?
Yes, sir, Your Honor.
Has he provided full, effective, and competent legal representation?
Yes, sir, Your Honor.
Mr. Barber, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor, we do.
And what is that agreement?
The agreement is that on cause number 330-566, Mr. Barber will serve 60 days in the Jefferson County Jail. In exchange for that, the state will dismiss cause number 328358 and 32958.
He doesn't have an affidavit.
Okay. That's the judgment. Mr. Barber, the state is offering that you serve 60 days in the Jefferson County Jail Mr. Barber, you will be given credit for any time that you are entitled to get by law. And the court cost in this case, Mr. Barber, is $457. Would you be able to pay the court cost of $457? Okay, Mr. Barber, could you give him that affidavit of indigence?
That's one of the cases that are being dismissed.
Okay, well, that should be up to date. I just need to get his financial information in it. Okay. Let me refuse that. Now, Mr. Barber, I need to get some information from you. Now, let me do this here. Mr. Adams, could you have Mr. Barber to fill out this financial information? Just,
Gonna be all legal, right?
well, just, let him fill it out, and then once you fill out his, financial information, we'll review. Now, Mr. Barber, just fill out a document that's, we could tell affidavit, put your financial information on this document. Is everything on this document true and correct to the best of your knowledge?
Yes, sir, Your Honor.
Okay, Mr. Barber, the court is gonna find that you're indigent, and because you're found to be indigent, the pursuant to Article 42.15 of the Texas Code of Criminal Procedure, the court cost of $457 will be waived. And the state is also dismissing cause numbers 328, 358, and cause number 329, 558. Now, Mr. Barber, do you understand the state's offer?
There you go.
Do you think that the state's offers in your case is fair and just?
Yes, sir, Your Honor.
And do you accept the state's offer?
Yes, sir, Your Honor.
Okay, Mr. Barber, the court is going to follow the plea bargain agreement that you have made with the state and the finding of you being indigent, and the court is going to waive the court costs, in this case of $457. And this cause numbers 328, 358, and cause number 329, 558, those cases will be dismissed. Mr. Barber, you're gonna stand on the X next to your attorney in front of our court clerk. You sign to get your paperwork signed, and once the paperwork is signed, we'll give you a copy of the dismissal, and you can follow the bailiff, and you have a blessed day. Stand on the X. Do we need his,
His son is here, the definitive.
come on up. What we're gonna do, we're gonna have him stand on this side. If you want to block his. Well, you just. Okay, I just didn't want to block it, okay.
Judge, I've prepared, as we discussed earlier, I prepared a written waiver of, the jury trial. In this case, both defense and the state have signed indicating, their waiver of the jury trial. State would be ready to proceed, first thing tomorrow morning. Judge.
Okay, now, Mr. Chase Ellis. You're represented by Attorney Keith Ellis, is that correct?
Yes, sir.
And Mr. Okay, Ellis, I think yesterday we checked, are you still in compliance with the state board, is that correct?
Yes, sir.
Okay, now, Mr. Ellis, well, Chase Ellis. I have before me a document that is titled waiver of jury trial. And let me do this here. Have you had an opportunity to review that document?
Yes, sir.
Do you understand the contents?
Yes, sir.
And is everything in that document true and correct to the best of your knowledge?
Yes, sir.
Okay, and Mr. Keith Ellis, as attorney for Chase Ellis. And let me do this here. And Mr. Chase Ellis, is this your signature above the line that's titled defendant?
Yes, sir, it is.
And Mr. Keith Ellis, there's a signature above the line that is titled attorney for defendant.
Yes, Your
Mr. Keith Ellis, did you sign this document?
Yes, it is, Your Honor.
And prior to signing this document, did you go over this document with your client?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge?
Yes, it is.
Okay, so the court is going to grant this waiver of jury trial. And we're gonna set Mr. Coleman, you and Mr. Ellis want to set this for a bench trial on tomorrow, you said?
State's ready to proceed tomorrow.
Yes, Your Honor. Whenever the court, the landlord for us.
Whenever, I mean,
Law's fine.
Judge, we anticipate this shouldn't take,
okay,
I actually have, Chase Ellis and one witness.
and the state have
okay,
one witness.
well, let's do, you want to do that 1 o'clock tomorrow? Yeah, let's do it in the afternoon, because we have a docket, well, yeah, we have a docket in the morning, 1 o'clock will be fine.
Yes.
Okay, all right, so let's reset the case. This case is being reset on this case until 1 o'clock tomorrow. Okay, for bench trial, yes, you may be excused.
Thank you.
And y'all have a blessed day.
I didn't get some paperwork.
Yeah, yeah, she's gonna get the reset. Okay. Our next case, our last case that we have left on the court's trial docket is cause number 326528, case of style of state of Texas versus Yolanda Renee Randall. We have Ms. Randall that's present in court. With her attorney, Ms. Randall, you can come up to the front, sit next to your attorney.
Before the jury comes over, you have a complete trial.
Pre-trial, okay, hold on a minute. Okay.
Hey, Judge, I will ask for permission for another one of those jury sheets for my client.
She can give us a copy.
There was one over here on our table.
Oh, he said,
No, he wants the,
he wants the one with all the information.
all the information. I get it.
Yeah.
Hold on, wait up, let's, our court report is right there. Let's hold on. Looking, where's, we gotta. Get. Oh, let me do this here. Court is in session at cause number 326-528. Case of Solid State of Texas versus Yolanda Renee Randall. Yolanda Renee Randall is present in court with her attorney Langston Adams, who is present before the bench. State is represented by attorney Lamar Johnson, who is also before the bench. I have before me Mr. Adams' motion for discovery of exculpatory and mitigating evidence. Now, this motion was filed May 5th, 2021, and I guess this is the first time the defense has asked, I guess, for a hearing on it since it's been filed. And so, Mr. Adams, do you even go forward?
Right, I'm ready.
Go ahead now.
No, what I'm asking is the judge to order the state to produce any exculpatory information in this particular case. And I want the order coming from the judge. Counsel is correct. They did give me access to the discovery portal, and I printed the police reports from the discovery portal. But as counsel should be aware, as well as his co-counsel should be aware, Brady encompasses more than just police reports. So for example, there are two police reports involving two police officers, Mendez and Battle. Brady also encompasses exculpatory information, and I'm quite sure even Mr. Coleman is aware of that. As it relates to exculpatory information, I have not been provided any type of exculpatory or any type of impeachment evidence as it relates to those officers. So if the state has anything in its file, particularly the Port Arthur Police Department, that would go to the impeachment, whether they lied, whether they was involved in any type of dishonesty, whether they had any internal affairs, I would ask the state, have you looked at your officer's internal affairs file? Do you know whether or not there's any impeachment information in that file? That would be encompassed under Brady. Also, Brady also includes impeachment evidence of witnesses. I anticipate their complainant is Lisa Ann Curtis. If they have any type of impeachment evidence as it goes to Ms. Curtis, that's also discoverable under Brady. I would venture to say from the discovery portal, unless counsel is telling me that he put it up there and I just didn't see it, that he's provided exculpatory information as it relates to Ms. Curtis. Also, they have another witness by the name of Rakisha Living. I'm unaware whether the state has added to the discovery portal any particular information as it relates to Ms. Living. Now, if they are going to suggest to you today, as officers of the court, that that information does not exist, then I'm good. We fine. Let's go to trial. All right. But I would ask you to inquire upon them as to whether or not the state has made an inquiry into its officers' files to determine whether or not there's any impeachment evidence, internal affairs on their officers, which would come in under Brady, and have they made any inquiries into their witnesses. All of that's, I'm entitled to that under Brady, and the law is clear in that area. And I think as a matter of law, if the court denies me that information, that would be an issue that she would have on appeal.
State, yeah, I have a response.
Your Honor, I would say first, it was counsel's obligation to seek a ruling on his motion prior to it becoming moot in the sense of we opened up our discovery portal, and I'm double checking right now, but I believe everything that that we have pertaining to this counsel has anything that's not work product or anything like that. So as far as there's no relief here to be granted unless there's something particular that Mr. Adams is requesting. I'm not sure what relief he can be granted. He spoke about impeachment evidence for the officers. The officers haven't testified. I mean, impeachment evidence as to what anything can be impeachment depends on what he said. What he says, it seems like he wants us to open up the file and just give them everything that the officers have ever done in their lives. I think impeachment has to be targeted towards impeaching something no officer has testified yet. So I don't think we can proactively or retroactively guess what is going to come out at the stand or guess what the officers may say or may not say that would lend itself to any type of impeachment evidence. I think that is just not feasible or practicable, Your Honor. I guess the bottom line would be that this point is moot. We're here at the eve of trial. There's nothing that we're planning to surprise Mr. Adams with. If there was something, I'm sure he would object if there was a piece of discovery that we have that we tried to introduce for the first time at trial. But we don't have any plans or anything like that. And this, as you pointed out, Your Honor, this motion was filed back in May, on the 5th of May. And here we are, August the 30th on the eve of trial. Discovery, all the discovery hasn't been had. I'm not saying at all, or I'm not trying to represent that counsel isn't entitled to discovery. I'm only saying that point is moot by now. We're here. We're not raising anything new. If we do, I'm sure you're going to object. But counsel has to have some type of relief that can be granted. And if that relief is moot, Your Honor, then I think the motion should be denied.
That's non-responsive, Judge.
Your Honor, this council here at the state has looked over the files, and I don't see anything in our records that would be exculpatory. And as far as addressing the officer's personnel file, that's something that our office does not keep. It's available to the public through the city of Port Arthur, and any sustained complaints against an officer is public record. So our office does not make it a point of practice to go into personnel files prior to trial. But if counsel, defense counsel is aware of something on a particular officer, we'd really love to know about it. But as far as our state's position is, we are not in possession of anything that we would consider exculpatory.
Okay.
Would that mean you have a problem with you signing an order saying the order to give me exculpatory information? And specifically, counsel did not respond to my argument. One, his argument really benefits me because the state would have been on notice a year ago or more than a year ago that I requested exculpatory information. And the question that I asked for the inquiry is it is on the state. Counsel, when he says, hey, this type of information is open records. That's not what the law says. The law says it is on the burden of the state, not the defense to go look it up, but the state to produce it. So if any of these officers have Brady material as it relates to the internal affairs, it's not my job to go find it. It's their job to go look it up and bring it. That's the law. And my argument is simple, and that's this. Since they were aware of this request, a year ago, if he's represented that he's looked at his officer's files, and that's what he's telling the court today, and that there's nothing in these files that's exculpatory, well, he's representing that to the court, and then I'm fine, let's go to trial.
Well, he's saying that he looked at the state's file.
But he didn't say he looked at the Port Arthur
I
Police
mean,
Department.
well,
Yeah.
when we talking about Brady, if I'm not mistaken, it's what's in the state's file. It's
Police
not
department.
the district attorney's office file. It's not what's in every file around the state on a particular officer. They just told you, apparently from what I'm hearing from Mr. Shearer, Attorney Shearer, is that they don't have that information in their file. What they have in their file is they're giving you access to everything that they had in their file. And if you haven't found Brady material in that file, apparently they don't have it in their file. That's what I'm hearing.
So I guess my motion is granted.
I mean, we could grant it. I mean, your motion basically says that let's see. Yolanda has in true understanding, respectfully move the court to order the state to disclose all evidence in its possession and in the possession of its agents, whoever's
The agents.
who are their
department.
agents,
The police department.
which is both favorable to defendant and material either to guilt or to punishment, including impeachment evidence.
And I think that there are cases to say, even when it comes to their witnesses, for example, if they're gonna call Lisa Ann Curtis as their victim, then they need to provide me with impeachment information on her.
Well, that's not in your motion.
No, the motion is global.
Well, no, global, I'm gonna read what word for word.
Okay, read word.
I mean, I just read this and it said that in it, everything, it says all evidence in its possession and in the possession of its agents.
That's all.
That's not, everybody's their agent?
No.
You
every
say
person-
global?
No, every person that's associated.
What you just asked for about some witnesses and stuff, I mean, this is just for their agents, possessions and that in the DA's office and the possession of his agents.
Okay.
That's all your motion says.
So I guess my question, is it granted or
And Your Honor,
denied?
the state would maintain that the Port Arthur Police Department is not agents of the district attorney's office.
Okay, I mean, I'm gonna grant your motion, I mean, you're entitled to Brady material. I
So,
don't think the state is objecting to that.
so here's where we are, then, since the motion is now being granted, if at the conclusion of this trial, that information is discovered, then that'll be another issue for appeal.
But that'd be an issue for appeal.
All right.
Okay, they'll, Ninth Court of Appeals will have to deal with that.
I guess, Your Honor, the only reservation I have is counsel is almost imposing on the state, some type of burden or trying to drive the state's case. The state prosecutes its case, how it prosecutes its case. We can't obviously hide any information. We have to disclose any exculpatory information, but to have one broad order that we have to turn over all exculpatory evidence by us or our agents without representing or without clearly defining who counsel believes our agents to be, and the fact that that's already an obligation on the state, and one that the state represents. It has fulfilled up to its ability up to this point.
So just so we clear.
Let me just say, I'm gonna grant what he's entitled to on the Brady. Anything beyond that, he's not entitled to.
I got you. So we clear for the
Okay.
record, the state is maintaining it does not have to provide me any impeachment information on Mrs. Curtis, who is their victim.
Well,
And that they don't have to provide me any information on its officers
what I'm,
because that's their.
That's not what
that's not
the
what
state's
we're saying.
maintaining.
We're saying we don't.
We're saying we don't have any.
we don't have to turn over anything we don't have. We don't have.
So then the question is did you make any inquiries into those files? I think the answer to that is no.
well,
But that's,
like I said, you're gonna be entitled to what you're entitled to get on the Brady. Okay,
All right, you grant the motion.
okay,
The other motion was the motion in limine, and that is that they not bring forth any particular character evidence evidence of any crimes of my client without first approaching the bench.
okay. Now, did y'all get a chance to see the motion for limiting? I mean, you just mentioned one thing.
There were several things in there.
I know, I'm just saying, if you grant the motion, what you didn't mention, they're not aware of. I want to make sure that they're aware of what's in this motion for limiting.
I think everything in there is standard.
Did y'all have a chance to,
Yes, sir. Your Honor, the only issue that I will have small issue is most of this seems to be form language out of the Texas rules of evidence and of civil procedure, Your Honor, and not criminal procedure, I'm sorry. And I don't see the benefit of you ruling on something that's already law, that's already imposed on the parties by statute. For example, dimensions of anything inadmissible under Rule 609B, that's going to be inadmissible whether or not you rule on it or not, Your Honor. And to sign a motion in limine that's enforcing what's already imposed on the parties.
I think what the motion in limine does is it prevents the person from just going into it without approaching the bench. So you have to come to the bench first. The court will be aware what evidence is trying to get in. The court can rule at that time. But what he's saying is instead of I guess him being required to just hurry up and make a motion, you already have a motion limiting you from doing that. And you have to approach the bench to get that evidence to see whether or not the court is going to grant it, to allow it in or not allow it to come in. I mean, that's what, now, Mr. Adams,
I just want you to rule.
I know, I understand that.
I just want to rule.
I understand what I'm saying. Now, Mr. Shearer, I see you.
I was gonna say that I don't have a problem with the motion in limine in the guilt innocence phase, but information about any previous convictions, stuff like that is extremely relevant during the punishment phase. And I may have missed it, but I didn't see any differentiation there.
He said something about it's in here in his motion in limine, saying to do a motion in limine in the punishment phase too. That's what you're saying?
That I didn't know this was just for just the trial.
This is a pre-trial motion usually for the trial.
Okay, and just in looking over the record that we have, we didn't see anything at all that was even usable as far as any type previous.
Okay, so my question is, do you have any objections to his motion in limine?
It's Mr.
I guess the only issue would be, Judge, if I'm not sure if the defendant is going to take the stand.
What?
Take the stand, but if the defendant takes the stand and she opens herself up to character evidence.
Oh, well, I mean, that's kind of different. But I mean,
that's the only issue I have, Your Honor, with ruling on something that's already imposed on the parties is.
So other than that, you're saying that you don't have any objections to it?
Yes, Your Honor.
That's what I'm hearing?
That's correct.
Okay, so the court will grant that motion in limine too. Now, let me do this. We have a,
What's that?
do you have anything else?
Yes.
Oh, you
I
have
asked for
another
a
one?
bailiff call. Yeah, well, not a motion, I got a bailiff call. I issued subpoenas for both of the officers, Timothy Battle as well as Patricia Mendez.
Okay,
And it should
I mean,
be-
you're asking for a bailiff call for,
to make, because you're gonna ask me before the jury, am I ready? And I can't answer that question truthfully without knowing whether or not these officers are here. I also subpoenaed Rakisha Living, and I'm assuming he's gonna bring his complainant, Lisa Curtis. So
Well, I
need
don't
to
know.
whether or not they're here.
I mean, we can find out, we can do that and find out here, but I don't know, that's not gonna stop the case from going on.
Well.
Okay,
if my-
because I mean, looking at the court has been told. Apparently, we pick a jury today.
Right.
Attorney Johnson is gonna be out tomorrow.
I didn't know that.
That's what Sheriff, that's what Ray told me. I thought he had mentioned that to you.
I didn't. I mean, I'm hearing that for the first time today. I didn't know that he wasn't
Okay.
gonna be here tomorrow. And
Cause I was, okay, well, we need to figure out.
that's throwing. Yeah, I didn't. I mean, you gotta realize I got a calendar too now. I mean,
I understand. Well, let me just, okay, I mean,
Yeah.
we got days, once this train get to rolling, this train is rolling.
right?
okay.
but I didn't know.
I know,
Yeah,
but let me do this. That's what Mr. Shearer mentioned. Now, Mr. Johnson,
That's right.
okay, what is now, we gonna be picking the jury in a little bit, but we just need to find out about, how this case is gonna proceed from here on after we pick the jury. I mean, what's your schedule tomorrow?
I've been interviewing for a U.S. attorney's position, and I have what I think is going to be the final interview tomorrow.
Okay. Okay, well,
But
let me do, so, well, we got another prosecutor.
yeah, somebody else can think about he's not, because at the end of the day, and don't get me
Okay.
wrong, I wish him the best. I hope he get the job. But
Yeah,
I use an example, Mr.
Yeah.
Coleman.
okay.
What,
But no.
I'm just using an example. Hold on, let me use an example. Mr. Coleman had a case with me, and he said he was swamped because he had all these other cases.
Well, let me, hold on.
Did I oppose it? I did
Hold
not.
on.
I did not oppose
Okay,
it.
let's do
But
this
now,
here.
once we
Wait,
start
hold on.
trial, and then you're gonna say.
Hold
you're
on,
not gonna-
no, what I'm saying is, I don't think it's gonna take, I don't think interviews take 8 hours. Okay, I mean,
What time is the interview then? What time?
I-
is it?
It's in Tyler, Your Honor.
Yeah, well, that's, because
Yeah.
Tyler Drive is what, a 3-4 hour drive?
Yeah, okay, well, we put like,
So,
we,
I mean,
we got a process, we got a first and a second check.
so whoever the second chair, they can.
Yeah, and that's what we're gonna, that's what's gonna have to happen. I mean, we got the
That's
second
fine.
check and take over. I mean, that's
I'm-
why
I'm
we
good
have,
with that.
yeah, okay, so let's do this here. We got a jury out there. We need the, Mr. Porter.
But Judge, you still haven't told me about this. Before the jury, you gonna say, are we ready? How am I gonna say I'm ready?
How you unready on,
No, I subpoenaed witnesses. I don't know if they,
okay, whether you subpoenaed them, I mean,
that's why I'm asking for a bail call.
you could ask for a bail call, but if I'm not mistaken, were you appointed on this case?
Yes,
Your
What-
Honor, if I may, I understand the point in subpoenaing the witnesses, but even if the witnesses were there today.
Right.
Here today, they're not gonna be testifying today. And,
No,
when
and-
they do testify, the state subpoenas witnesses all the time, and we have to coordinate with the witnesses when they come in. It seems to me that what, defense counsel is doing is trying to get the state to do his job and.
how am I doing that? I
These
sent the
people come in
subpoenas. They should be
today.
here.
I guess what he's
If I
saying
may
is that you
finish-
have a,
If I may finish.
Okay, go ahead.
you know,
That, in effect, doing this and making them be here today, and all these are people, that were, well, the officer I know was gonna be pro state, that,
I mean, I'm not going to do that.
So you're saying that a defendant that can go to jail, under the Constitution, you got a right to confront your witness. And we had a state saying when we subpoena a witness under our constitutional rights, somehow that's harassment. At the end of the day, I don't think they even issued any subpoenas. I did. And particularly, they have every right to subpoena whoever they want. I have a right under the law to confront witnesses against accused. That's in the Constitution. You can read it clear as day. So
Yeah, but
So-
let me do this here. Now, I mean, we can make the bail call, but the reason why I asked you when you was pointed on this case was at that point, you had a duty to investigate the case, and you don't investigate just by submitting a subpoena, issuing a subpoena as a way to get witness. I mean, you had to do it. You could have contacted these, I guess you had the contact information in the file that you had
I got it
discovered
from
in.
Discovery. I got it from. my lawyer.
Okay, well, that's not gonna,
I'm sorry, I don't mean to step on you about.
Yeah.
I think in the interest of fairness, Judge, for Mr. Adams' point of view, he has a right to know if he needs to request a writ of attachment to get his witnesses.
okay,
He
that's
has a
us.
right to know if they comply with his subpoena, and if he needs to go one step further. He has that.
Okay, I mean, we understand that. I said we was gonna call their name, but the point that I was trying to make is that that's not going to just stop this train from going, because, like I said, we had a year to try to, make contact with these individuals to find out more information about their case, about their testimony. So our bailiff is going to do that, and once we do that,
Well, Judge,
let's get that,
I'm
let's get
assuming
that,
He has to call Mendez, because that's the lead detective in the case.
oh, yeah, I'm sure, yeah, okay.
Your Honor, I don't think there's any confrontational clause issues. We're talking about when witnesses are going to testify. That's the only confrontation that that you have a constitutional right to.
Right.
And everyone is in agreement here that there are going to be no witness testimony today. So there is no confrontational,
Yeah, but
I think
he's
Mr.
talking
Copeland
about-
made the argument
yeah,
for me,
yeah, he's,
which is I have a right to know whether they're here or
Right.
not, to determine if I want to issue an attachment.
That's what it comes down to, just we.
Right.
Getting a little ahead of us to talk about confrontation.
right,
If
Right.
he has legally issued a subpoena
right.
to be here today.
Yeah, we can do that.
Technically, it was for yesterday.
Yeah.
He has a right.
Right.
Procedurally to attach these witnesses if they haven't complied with.
Okay, I mean,
Technically, I-
okay, let's do this here. The bailiff is gonna make that call. And once he, go ahead on and, you
I
can give him the
subpoenaed him
subpoena.
actually for yesterday, because yesterday was our trial day.
Did, well,
Yeah.
no.
Yeah,
I was thinking of something else.
I just want to call, see if they are there. Because technically, we were set for trial yesterday, so I subpoenaed them to be here yesterday. It's at the top. Look at the top. The name's long. One officer, Stephen, it is two officers. That's three. Piece of living. Piece of living. We're gonna do opening statements today? I mean, we can, we got time.
Well, we gotta pick the jury first.
Or you wanna do opening tomorrow?
Well,
All right. So
Okay.
there's two police officers and one civilian witness that I may need to have to issue a writ of attachment.
Okay, that's fine.
I'll work on that.
okay,
Your Honor, I would point out though, that, to be technically correct, those names should have been called yesterday. And so, we have no idea to know if they're out of compliance with the subpoena if
They should have remained in the courtroom when he told everyone yesterday, come back at 1:30. So
they were not called yesterday. So whether or not they were here yesterday, we have no idea.
okay.
And the fact that they're not here today does not mean they're out of compliance with the subpoena.
well, that's the issue on how you wanna handle that issue.
Yeah, I guess.
But
Notice.
I issued the subpoena. Subpoenas are in the file, they're in the court file. Y'all can look at it. And they were set for yesterday was the first day of this trial. And as counsel is aware, the court said, because there were other cases, we're gonna come back to today at 1:30. That's what we did. So those witnesses should have been here in that courtroom, in this courtroom, until they were excused, and they would have known to be back here at 1:30.
Did your subpoena tell them to be here in the courtroom?
So if I could be a court, it's like, it says with every subpoena,
No,
their
okay.
subpoenas look just like this.
Okay, no, my question was, did the subpoena say to be in the courtroom? That's
At
all.
9 a.m. to be in county court number 2.
Okay.
Yes. 9
Okay.
a.m. It's at the bottom. It says be here 9 a.m. yesterday,
Okay.
trial document. So that's 2 police officers, and that would also be the
A complaining
witness.
witness.
Well, not the
Yeah.
complaining witness, because I'm
A
assuming
witness.
without, that's gonna be the witness.
Okay.
Keisha Living.
Okay, so, okay, you're gonna work on that. Let's do
I'm
this.
ready to pick the jury. You are.
Yeah, that's what we're ready to get started on picking a
Just
jury.
one question. Are we gonna do opening statements today after we do that?
Well, we need to see what time this is. This is 3, it's going on, it's 2:45 right now.
Is it-
Go ahead on, let's go ahead on and get the jury in.
Cool. No problem. Thanks, Judge.
Okay.
Your Honor.
That's part of the fair trial. We want. And since nobody's talking, I'm gonna start calling people. Okay, how do you feel about assaults in general?
Assaulted, I can understand someone's their temper.
Okay, so like just a loss of control, loss of temper. Anybody in here got a temper? Okay, I'm guilty, you know. If I start getting flared up, I can feel myself turning red and stuff. Anybody ever assaulted somebody? Any of you got brothers, sisters? You want to roll around the yard some, Miss, Lee?
Yeah, and times also, I'm the big sister, so you find, my sister.
Where did you go to school?
Actually, several, but in the,
Okay. And we're from an era where stuff like that was settled. Nowadays, it seems like it's gotten out of control. Anybody else rolled around in the schoolyard? Right. Ms. Johnson, I see you nodding yes. Okay, they've got brothers and sisters, and honestly, my dad had me and my brother in church, because we fight. So, yeah, that happens sometimes, but does anybody just gotta say, well, that just happens, and that shouldn't be a matter for the government to be involved? Does anybody feel that way? Mr. LaPointe, how do you feel about that?
As the government stepping in, yeah, it's severe now. Yes.
Okay, and in your mind, what would be severe?
As in a fight spilling over, not necessarily getting up a fight for how you all used to handle it, but, just the fight getting out of hand, someone being hurt, physically after the hospital.
Okay, so if it gets to the point somebody has to go to the hospital, anybody says that's still no big deal? No? Okay. And I may have asked this already, I want to make sure I covered, has any of y'all ever been a victim of an assault? This, Rose? What, if you don't mind, how severe was it?
I've worked inside men's penitentiaries for 25 years.
Okay. Okay. So TCJ?
And feds, I've worked for the feds for 20 years.
Okay. Hey, thank you for what you did. And Miss, Whitney?
Oh, well. Ex-husband.
Okay, that's okay. You don't have to go into it. That's an issue too. Sometimes it comes up in domestic violence cases when we have domestic violence cases that come up. And honestly, we do have sometimes when we're talking with jurors and they say, well, that's just what married people do. And I kind of have a problem with that. Mr. Daly, how do you feel about this whole assault thing?
This is Dr. Daly.
Doctor, okay.
I've never done it before. Assault, I don't necessarily think it even needs to get to the level of the hospital. I think it depends on the context, because certain sexual assaults or even personal violations can be very affronting. So I really think it depends on the context. It depends on the reactions of the parties involved.
Okay, sure, good. Does anybody consider what we call the repercussions of something? what may be a simple shrub. What can that result in?
Come on.
Yeah, somebody come back. Mr. Samuel? Okay. And do they come back with empty field? Okay. Yeah, when you look at the big picture, is this what we want people doing out there? Settling their differences that way? I see several head shaking those. Mr. Hall? What should be done?
Well, I'm soft, I want to defend myself. I got the right to defend myself against anybody or anything. Anything, so.
And he brought up self-defense, and so let's go down that trail. Does anybody feel like they should never defend themselves? There are people, you know, and that's your opinion. As an officer, I always be approached by people wanting to know about getting their license to carry a gun. That was a big thing, you know. And of course, why are you going to carry it? You're not going to use it, and that will be the first thing I ask them. You know, and there's some people that will tell you straight up, I can't do that. But so, you know, there's no shame saying, you know, I'll back away rather than defend myself. Is backing away an option? Miss Martin, is it? Okay, how do you feel about that?
Sometimes it's better to avoid the situations that people fall,
Okay,
depending on whole situation that you can.
okay. So the apprise the situation and decide whether or not it's.
One person, or you just want.
Okay, what, I'm gonna pick on a little more here. What would be a situation in which you'd say it's better to back away?
Maybe, you know, someone is agitated, maybe intoxicated, or it might not be good for you, because they're gonna hit you or do something to you, maybe run or get away.
Anybody else? Mr. Rogers, you have two Mr. Rogers, by the way, so, how do you feel about that?
I mean, it really depends on who the parties are that are involved. I mean, if somebody's dangerous, then I would stay away from them, but I mean, like, if you know what they're capable of, then.
What about location? Would that make a difference? We've already talked about schools. And we do have a problem with this in schools. And, you know, just all you gotta do is look at the news and see where BISD is talking about the number of fights they're having already this year. So, you know, yeah, there are some locations. What about other people around? Does that make a difference? Ms. Kimball, how would you feel about that?
I think if other people around are also involved in, you know, you personally have more people that are attacking anyone. Maybe I think there's just that we know that they have absolutely.
Let's see, in the back of the room, Mr. Rogers in the back. What about, you mentioned about other people around that may get involved and such. Would that sway you one way or another as far as getting involved, or would you even come back at somebody, and let's say they made offensive contact to you, would you even come back to it?
Wasn't how serious contact was.
So let me ask you, the more serious, would that be, you'd be more inclined to defend yourself, or? What if it was minor?
Yeah, I have trouble. Yes,
Okay. What about, oh, they're just drunk and stupid?
I'm bored.
Has anybody ever run across people who were drunk and stupid? There's certainly maybe not drunk, but it seems like a lot of stupid people, you know, especially if you drive. So, Ms. Rose, in your experience and you're trained at de-escalating, but in that position, how feasible is de-escalation?
Well, it depends. I mean, if I'm in a housing unit with 147 inmates by myself, it's gonna make a difference. I mean.
The numbers
it-
aren't there.
It depends on the situation,
Mhm.
and that's where you have to be able to read the situation very quickly and then react appropriately in order to either preserve your own safety or react in a way that, you in the situation.
Okay, and it is complex. It can be very complex. And there's a lot of factors that are involved. But the overall position the state has is that if you can avoid violence, avoid violence. And that's what we're talking about with an assault, is it is violence. What about previous relationship? And I'm not talking like a dating relationship or anything like that. I'm just talking about somebody you know. Mr. Holmes, how do you feel about that?
Well, sometimes when you know someone, you know how to get under their skin. You also know what you're dealing with as well. So it's a choice whether, you know, you want to it's not like you're in a situation.
Do you have people to get under your skin? Do you hit them? Okay. Yeah, we all have our buttons. There are buttons that we can have that we get pushed. Is there, you know, is there an excuse for while they push my button? Do they know? You know, if you know them? How many of y'all work with somebody that you'd rather not be around? Can I see a couple of hands? Ms. Ford? To avoid.
Yeah, you're trying to avoid it.
This thin one on the back. Here, you sitting back and watching all this. You ever foresee a situation where you couldn't avoid, you'd have to do something? Does anybody got any questions of me? Sometimes you think things are cut and dried until you start really cutting it up and then you realize it's not all that, it's not everything. We need to look at this and like I said, and I am going to throw this out here simply because this is something we as prosecutors have to deal with. We talked about at the very beginning of fair trial, and she's entitled to a fair trial. The state is also entitled to a fair trial. If an officer comes and testifies, how are you going to take their testimony? Are you going to hold their testimony higher than someone else? No? Okay, you're going to hold them. Now, here's the real kick. Are you going to hold their testimony lower than someone else? One of those, you know how those police are type situations. What we want, Mr. Adams, everybody in here, is a fair trial. And fair means to come in here and put aside not your common sense, but any past experiences that would make you not be fair in this situation, that would prejudice you one way or the other. Because we need to be able to judge this case on the merits of this case and not some past experience or something you saw on YouTube or the internet or something like that.
Mr. Chair, you have 5 more minutes.
Thank you, John. Is there anybody in here that says, I don't know, I kind of have my problems? Yes, Mrs. LaPointe? No, I'm sorry. Lee.
Well, just like I work at the federal and state prison, but then in the medical nurse here. Worked there for a long time. I just retired. And I was in a lot of situations where I would be seeing the officer or the offender there, and one claiming one thing and the other claiming the other, and I would be seeing the results of the encounter with their injuries and stuff. So I would come to that conclusion, and I'll be honest, 90% of the time I was listening at the officer's viewpoint and really leaning in that direction with that because of the same situations that I was in. Even though they would have the videos of them, you know, and how it was doing. But so I would be honest, I mean, I would lean more toward the officers. Because so many situations that they have been in, and defending themselves or defending the situation. So, yeah.
You kind of
Yeah.
predisposition.
Only because I've seen so many.
And thank you for your honesty, because, you know, we all like to think of ourselves as unbiased. But a lot of times we have biases that we just aren't aware of, or we never thought about before. And sometimes it's because of life's experience. Anybody ever been bit by a dog? And this McKay, is it McCullough? I couldn't read my own scribble. So how do you feel around dogs now? Okay, so, you know, I know that my mom had a phobia. And when we were living right next door to her, we got a mastiff, about 135 pounds. And she got to where she loved that dog and that dog loved her. So sometimes our experiences can cause us problems, but then at the same time, we can also overcome those. And so that's what I'm asking here is that if you're saying I can't, you know, I'm gonna be biased, please let us know. And that bias can go one way or the other. It can go for or against the state. It can go for or against this rant. Okay.
Okay. Mr. Adams?
Good afternoon. I want to look at every one of you and tell you that I know some of you said that you do not know me, and I get that. But I can tell you I've been practicing law since 2002. And there has never been a case in my life where I have picked a jury and I was not scared. Not one. I've tried cases as simple as traffic speeding tickets. I've tried cases as high as murder. And every last one of them, I'm scared. And I'll tell you why. The whole point of voir dire, the whole point of what we're doing right now is to determine whether or not a potential jury, which would be you, can be fair to Ms. Randall. I disagree with Mr. Sheriff when he says that fairness is about the state as well as her, and I'll tell you why. I'll tell you why. See this big book I got right here? Texas Criminal Codes and Procedures. It has Texas Code, Criminal Code, there's Texas Constitution, all in it, right? And when I go to the first article, due course of law, no citizen in this state of Texas, none, shall be deprived of life, liberty, property, privileges, or immunities in any manner disenfranchised except by the due course of law. What does due course of law mean, Mr. Copeland? What does due course of law mean to you? That as a citizen, you're a citizen of the United States of America, right? You're a citizen of the great state of Texas, right? You cannot be deprived of your life, your liberty, your happiness without the due course of law. What does that mean to you?
There's a process.
That's a process. And who should that process be fair to?
Everyone.
Okay, you say everyone. Who's the person, Mr. Rogers? Who's the person whose liberty is at stake?
Yours. Or the party.
The person who stands what? Who agrees with Mr. Rogers? Whose liberty is at stake in this particular case? Tell me, well, who would you say?
In this particular case, your client.
My client. Who would agree with that? Disagree with that? Who disagrees with that? Would you disagree?
No, I agree.
Her liberty is at stake. Because ultimately, for a Class A misdemeanor in the state of Texas, you could receive a fine of up to $4,000 and or a year in the county jail. So if she's convicted by you, could she lose her what?
Freedom.
Her freedom. Now, Mr. What's your name? Got Ms. LaPointe. I bet you probably never been in any trouble a day of your life. No, and I get that. But if you were, would you want your lawyer to care? How about you? How about you? How about you? How about you, Mr. Would you want your lawyer to care?
Sure.
How about you? How about you? Let's reverse that for a second. Miss, would you want the jury that's selected in your case to care? Would you want the jury that's selected in this case to care about possibly taking away your freedoms? Would you want them to care? Or would you just say, hey, let's just, hey, get in, get out, it doesn't really matter? You want them to what? To care. So let's move to the second thing then. Because remember, you said to everyone, I'm gonna come back to you. 105, right underneath 104. Remember I read 104, talked about due course of law, all right? So I'm gonna read directly under it, and I'll let you see yourself. 105, what does that say? Rights of accused. Rights of accused. So are we talking about the state, or are we talking about the accused? Who are we talking about? We're talking about the accused. So we're talking about rights of who? The state of Texas or who? The accused. So when we read rights of the accused, in all criminal prosecutions, the accused shall have a speedy public trial by an impartial jury. Who has the right to a speedy and impartial jury? Who? So when I say I disagree with him, do you see why? Her rights are at stake in this case. Do you understand that? You read rights of who? The accused. Now I got a question. If anybody thinks that, hey, it should be about fairness to the state, fairness to her, but it's not, but disagrees that this is all about her rights, let me know. Anybody, you? You? Mr.
Are you saying that that it should be more in favor of your point of view with the jury?
Absolutely, because who has what's called the presumption of innocence? I'm quite sure y'all heard that before. This is not the first time I bet you heard the word presumption of innocence, right? Right? Right, I'm quite you have, right? Tell me what you understand the presumption of innocence to mean.
That's accused, everyone is supposed to be innocent until
By what standard?
by the local laws or federal laws or.
You're good. I'm not trying to put you on the spot. That's an excellent answer. I think your husband obviously is a doctor, right?
Yes.
Right, right. Think about when your husband does diagnoses of people, right? Whoever the person gets the diagnoses, they kind of want some certainty that he's right about that, right? Because I don't want you saying, for example, I got tuberculosis and I don't have tuberculosis, right? I don't want you saying that I have the big thing going on right now is COVID when I don't have COVID, right? Right? So in a criminal case, if we presume that she's innocent, you tell me what a presumption is, ma'am. What does it mean to presume something?
She is innocent.
Let me give y'all the easiest presumption there is. Sir, what's your name? How you got here today?
Drove.
What kind of car you drove? And I ain't got to know that. What kind of car you drove? What are your keys? Tell me right now, look at me in my eyes. You're 100% sure your car is out there right now.
No, I'm not. I hope it is.
You know? Now, why he couldn't answer that question, ma'am, and say, I'm 100% sure my car is out there? Why he couldn't say that?
Because it's downtown Beaumont.
You said, no, hey, that's a good answer. Okay, but what, at the end of the day, though, he presumes that his car is out there, but he doesn't have absolute what? Surety, right? So when you sit as a juror, here's what I'm gonna ask all of you. The way you presume that your car is outside, you must also presume that she's what? Right, and if you don't have that same degree of feeling that hey, she's innocent, like you feel your car's outside, then are you being fair to her or are you not being fair to her? That's a question. Sir, what would you say? You're not being fair. Who agrees with that? Raise their hand. If you don't have that, do you agree or disagree?
I have no, in terms of the presumption,
Yes.
she's innocent at this point.
Okay, so you presume that she's absolutely innocent, right?
At this point.
Well, what you say at this point, notice you keep on making a point at this point. So what would change that?
Well, it's just like the car.
Mm-hmm.
I hope my car is out there too, but I really don't know that
I'm listening, go ahead.
until I go and leave and get in my car. So
Okay.
at this point, I have to presume that she is innocent.
So I guess when you said that Mr. LaPointe, when you walk outside and find your car not there, you're 100% sure it's not there anymore, right? Because you're a witness that your car is not there anymore, right?
Correct.
Okay, so in a criminal case, what type of evidence does the state have to prove? What's the burden of proof? It's proof beyond a reasonable what? Doubt. But this case involves a different twist. And here's where I'll spend the remaining of my time. Because here's where we determine whether or not you can be fair, not to the state, but can you be fair to her? I didn't make it up. I brought the book to you and let you read it yourself. We talked about rights of whom to a fair, impartial what? Trial. I didn't make that up. I'll let you read it, didn't I? So when we start talking about what's fair to her, right? Then the question becomes, can you follow the law? Right? Because if you can't follow the law, can you be fair to her? So let's talk about some things for a second. Remember, Mr. Sherrill asked many of y'all, hey, how many of y'all been in a fight before? You know, he asked that question. And I think somebody, what's your name in the back? Ms. Johnson, you said probably not as a little child. I believe you, Ms. Lee, talked about rolling. In fact, here's what you said, Ms. Lee. Y'all can tell me if I got Ms. Lee wrong. If I got it wrong, please let me know I got it wrong. But I thought you said something to the effect that, hey, when you were a girl, you were the big sister, and if somebody messed with your sisters, y'all handled it at the pole. Did I get you right on that? How many of y'all disagree with Ms. Lee? Say Ms. Lee got it wrong. Who disagrees? You think Ms. Lee has it right? You think Ms. Lee has it right?
Absolutely.
Do you think Ms. Lee has it right?
As in what?
When she says that, hey, about handling, explain what you meant by handling at the poll, you the big sister.
If they were picking on my brother and sister, I would be up protecting them at that time in the hall. And then, okay, we're meeting at the flagpole.
To duke it out.
Yeah,
So notice what she said. Okay, you said, what's your name, Mr. What? Michael what?
Right.
Okay, so let's hit pause on that for a second. Ms. Lee, most of y'all say y'all agree with Ms. Lee. If you're picking on one of my siblings, we can handle it at the poll. We can handle it at the poll. Most of y'all agree with that, right? Right? Okay. I'll go to you, Ms. Rose, right? You said that you work for the prison.
I did.
You told us you investigated a whole bunch of fights.
Sure.
You seen a lot of, probably killing, you probably seen a lot of stabbing, you probably seen a lot of blood, haven't you?
Yeah.
I got a question for you. Since she's the expert, at least because what she does for a living, she's an investigator, right? That's what she does for a living. She works for the federal pen, right? You investigate fights. When you investigate a fight, you gotta get this side and you gotta get that side, don't you? Okay, let me ask you a question. You have more experience with fights than anybody in this room right now. Probably so. Maybe not. Okay. You tell me what makes a fight fair. And tell me what makes a fight unfair. You tell me. You can answer that question any kind of way you want to. What makes a fight fair and what makes a fight unfair?
Well, in my experience, a fair fight would be one-on-one, and an unfair fight would be multiple. I mean, it just happens, I mean, it happens.
I absolutely agree with you. But now what I want to find out if everybody in this room is going to agree with you. What the lady who's investigated more fights than anybody in here, she says when it comes to a fair fight, one-on-one is a fair fight. But when it begins to be multiple people, it is no longer a fair fight, is it? Right? It's no longer a fair fight. Would you agree with that? 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 Yes or no? That's okay, I'll keep going. Would you agree with that? Huh? Would you agree with that? Would you agree with that? Would you agree with that? I know you would, because you just said it. How about you? How about you? How about you? In the back. Back. Now let's hit pause.
There's a caveat to that.
Okay, but are we gonna come to that
If I
caveat in a
bring a
second?
knife to a fist fight, then, you know, it doesn't matter whether it's one-on-one or not.
I absolutely agree with you on that.
If I bring a gun to a knife fight, then, I mean.
I
you know,
absolutely agree with you on that. But hold on one second. Let's think about why she said that 2 against 1 is not a fair fight. Because if it's 2 against 1, we don't have to talk about knives. We don't have to talk about guns. 2 against 1, you can kill a person 2 against 1, can't you? You kill a person 2 against 1, can't you? Who disagrees with that? 2 against 1, you can kill somebody, wouldn't you?
unless they're coming to work.
Yeah, not unless they come for one. But you kill somebody 2 against 1. It's not a fair fight. So I got a question for you. Mrs. What? You know? 4? Oh, huh? Oh, 4? I heard 4. We have Mr. Holcomb to my right, and then we have Mr. LaPointe to my left. You see these 2 gentlemen? If they try to jump on me, would it be a fair fight? Hit pause on that for a second. Hit pause on that for a second. Find something. Find something. See the speaker right there? See the speaker? I have my hand. That's the object in my hand, right? Them 2 coming at you. That's not a fair fight, is it? You think it's within the realm, can you take this and throw it at one of them as hard as you can? Would you? Why? To defend yourself. Absolutely. Absolutely. Because if a fight is not what? fair, then I can take the means necessary to defend myself in an unfair fight. Now, who disagrees with that? How about you?
I agree.
How about you? How about you? How about you? How about you? How about you?
I agree.
How about you? I got an idea what you're gonna say. How about you? How about you? How about you? How about you? You're the doctor. How about you? 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 Because let's think about it for a second. Let's change the fact. I got two men on a woman. But how about, you're a big guy. What's your name?
Michael.
Mr. Michael, right? You got an umbrella in your hand, don't you? I'm willing to bet you if you took that umbrella and hit me with that umbrella, you would probably draw blood. If you hit me real good. If you poke me with that umbrella, you probably draw blood. I'll bet y'all $1 million right now. If these two gentlemen tried to jump him in this courtroom, he would hit him with that umbrella. Who would say he wouldn't? Tell me, you think he wouldn't?
Oh, absolutely.
Oh, absolutely he would. You think he would hit him with that umbrella? You think he would hit him with that umbrella? How about you? Would you use that umbrella? Them two jumped him. Yep. Because from the very beginning, the fight starts off as what? Unfair. How you feel about him using that umbrella? So now we get to the essence of the law. Am I getting into what y'all following on board? So let's get to the essence of the law. Remember, I told you guys, I said, hey, the only reason we're here for voir dire, the only reason to determine if you could follow the law, and whether or not you would be fair and impartial, right? That's what I said. Y'all remember that? Remember, Mr. Rat said to y'all, said, hey, no football games, player runs off the football field, his teammate, congratulations, pops him on the first, good job. Okay. But that other example is if I'm walking down the mall and some man walking this lady and just pops on the butt, that'd be an assault, wouldn't it? Because in his example, you have the element of what? Consent, right? Boxers have some degree of consent to punch each other, right? Y'all agree with that? So when my teammate taps me on the butt and say, Langston, good job. You caught that touchdown, baby. That's right. And he taps me on my butt. It's implied consent, and that's a part of the what? Part of the game. But what's the other way that we can justify a quote unquote assault? And you know what? Who was the lady that talked about self-defense? Who was that? Was that you? I think you mentioned. Who's the one? One of y'all mentioned self-defense. I forgot which one it was. Who was it? Was that you? Help me out. Y'all help me. Who was it? It was one of y'all. Who was it? Which one was it? Who was it? I believe that was you, Ms. Lee, who talked about self-defense. Because let's think about it for a second. You can justify an assault by self-defense. So in the example we gave, these two gentlemen try to jump my friend in the back. He hits him with that umbrella. Would he be justified? Yes. He's acting in self what? In self-defense. Who threw the first blow?
Mr. Adams, you have 5 more minutes.
My question to you is, under Texas law, in these 5 minutes, let's just cut directly to the chase. All right? Let me tell you why I agree with Mr. Sherrill. If this case is all about Miss what? Soccer. If this case, Miss Soccer, is all about my client and the lady who we mentioned in this case is Miss Lisa, huh? Yeah, Lisa. If she walking for no reason to stop her, bam, or pick up a stick and hit her, bam. I can tell you right now, that's an easy case, guilty. It's not to talk about because I can just walk up to you and just hit you, right?
No.
Right? So obviously you're gonna get two stories, right? So you already know without knowing one thing about this case, my client ain't in this courtroom saying, I just walked into this woman and I just hit her, right? Or you gotta know it from a common sense standpoint, don't you? Because you said you investigate fights and you get two sides of the story, right? So here's the thing. When you got two sides of a story and you got one person saying she started it, then you got the other person saying she started it. As the jury, you determine the weight to be given to the what? Evidence, right? So now how do we get to who we might believe? Well, he told you, he gave you a hint. He said, well, why don't we look at the relationship of the parties, right? Does anybody got a motive? Does anybody have reason to be messed up, right? Assume that we were absolutely married, us two, in love. And for whatever reason, we split. And now you with Mr. Holmes, right? Do I have any motive to have animosity towards him? Maybe, maybe not, huh? Maybe, maybe not. Could that motive go into your idea as to who started and who didn't start the fight if we both saying opposite things? Could it? So wouldn't y'all agree? How about this? How about if he tells the story or I tell the story and you find out one of us lied in the story? I said it happened this way. He said it happened this way. Then he changed his story. Does that go to his credibility? Does it go to his credibility if he tells multiple stories? If he's caught in inconsistent
You have 2 minutes.
would that go to his credibility? Who would say yes and who would say no? Telling inconsistent stories.
If he was coerced or not.
All right, it's nothing. Remember, he talked to y'all about this. I'm getting this from him. I'm not taking this. I'm getting this from him. Remember how he asked y'all about the Club 21? And would you have any problem with somebody being in the club? Remember, y'all got that from him, right? Okay, so let me go to this then. If one of the parties is drunk at the club, been drinking alcohol, drunk, and that person gives their story versus somebody that's sober, could that influence your ability as who lying and who telling the truth?
It could.
How about this? One person, the fight happens, we get in the fight, right? Police get called, I stay on the scene. You leave the scene and take off. Now we get to,
Well, 1 minute.
now we get to who version we gonna believe. The fact that you took off, did that impact y'all? So when you got two people saying opposite things, right? Then I'm agreeing with him. You can look at what? Circumstances, right? You can look at circumstances. In my last 2 minutes, I asked all of you this.
Mr. Adam, you have 30 seconds.
I thought I had 2 minutes. I thought
2
you said
minutes was a minute and 30 seconds ago.
Okay. I thought it was, well, here's where I bring it to a close. I look forward to trying this case with you. And as I begin, I will end. I'm still scared. And whoever is selected on this jury, I ask that you listen attentively. Listen to the facts of this case. And I think you'll find that my client acted in self-defense.
Your time is up.
She started nothing in this case. Thank you for your time.
Okay. Okay, ladies and gentlemen of the jury.
I have a person. We have one to bring up.
Okay, we're gonna get to that.
All right.
Okay, ladies and gentlemen of the jury, at this time, we're gonna have each and every one of you to follow the bailiff back into the hallway, and they're gonna be some of you that may be called back into the courtroom for some follow-up questions. So at this time, follow the bailiff.